welcome, Amar. I will hand it over to you, and I will allow you to share your screen.
Great, thank you. Thank you so much, Paisley, Alicia, and Ruby for having me. And it's great to see some familiar names, some familiar faces as well. So hoping to kind of dive into some of the basics and fundamentals of intellectual property. About 15 minutes to no more than an hour sort of presentation. And yeah, this is just it's one part of all the laws that I'm sure all of you will come face with if you haven't already when it comes to running your studio, developing games, whether you're doing that on your own in a team or you're working with a studio where you're employed. But intellectual property, this is the most important aspect of the law when it comes to the games. So we'll be diving into this, and just we'll check to see if I can share my screen because I have a presentation or slides to go with this. Here. And can everybody see that okay? Great. I have a couple of screens here, so don't mind as I'm just trying to organize things. Great. So we're here to talk about video games and in particular intellectual property. I mean, a great place to start is acknowledging all of you and what you do as developers, whether you run your own studio, as I mentioned, or working in another studio. You're all committed to putting these games together. And someone as such as myself, I love video games, and I'll sort of expand on that a little bit more as we get into this and why I decided to call myself a video game lawyer. But video games is a beautiful form of art / entertainment / it could be anything really. And here in Canada, we have one of the largest markets when it comes to producing and developing video games. I think we're around third place in the market behind Japan and the United States. And we have some amazing titles that have launched over the course of the past few decades. With some of these, just to name a few, and hopefully in a future iteration of this presentation, we can add some of your games to this list as well. So about me, I'm a lawyer. When I was in high school, I still do love video games. But when I was in high school, I wanted to become a video game developer, and I guess you could say that I was technically. I used to use a software called RPG Maker, and back then it was, I think, the 2000 iteration, and I don't know what level they're at nowadays, but I'm sure they have a more advanced version. Well, as you can see, it didn't work out for me because I'm wearing a suit and I have to talk about the law. But it's my way to contribute and get back into this industry that I love. And the best way I can do so is to help out the developers, the ones who make the games, to make sure that they've got all their T's crossed and their I's dotted. And honestly, making sure that they protect their IP and their games. And that's something that comes from inside as a developer, right? These are things that you've envisioned, you put together. It's a combination of your experiences, and then you've created it in some sort of a way that gamers, users, anybody can interact with in whatever way that you've envisioned it to. So myself, I started out as a bit of a corporate lawyer, and I did civil litigation as well. I wasn't a fan of civil litigation. That's the area of law where I was in court every day, and I'd have to argue and fight, and nobody was happy. Even if I won for my clients weren't happy. It's not a fun place to be, but it's a very important place when it comes to understanding the law. And I've taken some of my experience there to understand, hey, what does the bad side look like? What does the worst case scenario look like when things go wrong? And I've taken that and I've kind of brought it with me where I practice now as a corporate lawyer and intellectual property lawyer, where I help clients. I help clients such as yourselves, particularly entrepreneurs, corporations, video game studios, developers, sometimes publishers as well, to make sure that they've got all their legal ducks in a row and that they can avoid worst case scenarios. Being proactive and making sure that they're set up for success rather than helping them out when things go wrong. And so I've been a lawyer for about 5.5 years now, and I started my own practice, Revere Law, in the middle of the first year of the pandemic in 2020. It's a good opportunity to kind of self-reflect. I'm sure many of you did the same. And it was a way for me to align my experience, my skills with my passion and seeing how I could make it more useful. So I've been operating my firm for about 3 years now. And over the course of this time, I've helped many startups succeed from the idea phase to launching to getting funding and growing. Corporations, all different types, and my favorites, video game developers, indie game developers in particular. There's a lot of excitement of kind of getting to see what games you're working on, what ideas you want to bring to life, and see how I can be a part of making sure that you do so with somebody looking over your back. Just a few of these games that are listed here on this slide. They're some of my favorites of all time. Final Fantasy VIII, huge Final Fantasy fan. That was one of the games that really just kind of drew me to gaming, even though I'd say Donkey Kong Country was the one where I got super excited for. I got my Super Nintendo as a kid, and the rest is history. And these days, it's tough. It's tough to be a lawyer and play games at the same time, but I try to make I try to do that as much as I can. And at the moment, I'm playing Tears of the Kingdom. I have been for many, many, many months. It just takes forever, which is a good thing. And Cyberpunk, which after their updates is a pretty amazing game. And just goes to show as developers, hey, just focus on the end goal and just work on getting it there, because eventually you might have the product that everybody expected. And I'm on my third playthrough of that game. So, but yeah, that's just a little bit about me. And now we can dive into the presentation. So I have to do this at the beginning, and I'm going to play on one of my favorite video game lawyers, Phoenix Wright. Just for disclaimer purposes, I'm not your lawyer. And this presentation is for education and informational purposes. So anything that's discussed, it's not legal advice. It's very generalized, and I'm sort of just speaking on my experiences and providing some education. That being said, I believe that there's going to be a Q&A session towards the end. That will be quite generalized in terms of the advice that I can give, but feel free to reach out if you ever have any specific advice, and we can see what we can do there. So we're going to be covering intellectual property today, but I also wanted to touch on some of the topics that we're not going to be talking about, but are very important for developers to know about. So intellectual property is what we're going to cover today, but developers should know about how to set up a studio, and whether they've already set up the studio, how to run, operate, and manage that studio, because it can be a solo operation, but it can evolve into a multi-party organization where you've got a team of employees, maybe even a fleet of your own lawyers. But yeah, that's understanding that is an important aspect of video game development. Funding. Nothing gets done unless you have the money to get the ball rolling. This is a topic of its own, but very important to know. And the one point I'll make on this is that there's a lot of opportunity out there. And broaden your your scope when you're looking for funding or you need assistance with funding. There are a lot more resources out there than many think. and of course, hiring and working with others. We're going to touch on working with others to an extent in this presentation because IP is heavily involved in that aspect. But it is important because you're always going to be working with someone. You're going to be having some sort of relationship with someone, whether that's within your studio, externally. I mean, if you are producing games, essentially you want somebody to be playing that game. So there will be a relationship with the players as well. And so understanding those relationships is something that developers should have a good idea about right from the get-go. So today's agenda involves an introduction to intellectual property. It's going to be quite high level because intellectual property is quite sophisticated, and we could really dive into each aspect and break it down, especially when it comes to video game development. Then we're going to dive into some of the fundamental aspects of IP. So we're going to talk about some of the categories that maybe you're already familiar with, such as copyright, trademark, patents, trade secrets, moral rights. And I also will be sharing some examples of what IP looks like in each one of those categories. Then we'll discuss some strategies that you can start implementing today if you haven't already, to take advantage of how to utilize, protect, and enforce your IP. Then getting into understanding how to use IP, whether that's your own, whether that's working with third parties, and having a good sort of solid grasp of how to use it, because that's one of the most important things when it comes to producing the game and getting it out there. You want to make sure at the end of the day that the IP that's in your game, it's usable and you have the legal rights to do so. And then finally, figured might as well touch on the topic of how to work with video game lawyers or how to work with lawyers. Because yes, this is all information, but it would be great if you can use this information constructively with lawyers that can help you get some of this stuff done. So jumping into intellectual property. Well, what is intellectual property? Well, it's there's a definition for it, and I'll show that in the next slide. But a high level sort of overview is that it's real legal rights for things that might not actually physically exist. If we compare this to, say, real property rights, right, which is or real property, you might think of, say, your house, land, something like that you can physically hold. Intellectual property starts with something that comes out of the mind. And it's incumbent on the developer or the artist, we'll stick with the term artist for this purpose, to kind of bring that idea into something physical in life, whether that's a painting, a movie, piece of music, or a video game. And when it comes to video games in particular, IP is quite sophisticated, as I mentioned. A game, if you compare it to, let's say, a picture is a painting, and I know I'm overly generalizing here, but just to kind of give you an example, a painting is an image, and you can interpret that image how many times you want or in however way you want to, but it is an image. If we were to kind of say, well, how do we describe it? How do we break it down? It might be a 2D piece of art. If we were to kind of add dimensions to that, it might turn into a movie, moving pictures, where we've added maybe music, we've added motion, all these different elements that complicate or add on to the IP. So where we have a picture, we might just say, this is one piece of IP. It's something that might be copyrightable. But then as we move to video games, and we break that down, there's a lot more involved to that. It's not just the picture. The picture might just be one character model from one angle, right? You've got the music, the soundtrack, you've got the codes, the script. You've got all of these pieces that you can break down, can all be considered IP. And in particular, these are something that you would call an IP asset, because assets are things that you could break down into individual things. So all of these are IP assets. Your game itself is its own IP asset. So if you look at a game, the game itself, it's an IP asset. But then if you open the door into it, you can break it down into almost an infinite amount of IP assets. And so that's why it's important to understand this. And I'm not saying go and make sure you've registered every single piece and do your inventory, but that is something to kind of consider in terms of how complex you can get. So in Canada, intellectual property, it's broken down into different types of categories, as I mentioned: copyright, trademark, patents, trade secrets, and more. For the purpose of video game development, we're going to be focusing more so on copyright, trademarks, trade secrets, moral rights, which is a subset of copyrights, and patents to an extent. In Canada, this area is governed by the federal law. So although in other areas of law, provinces will have their own rules and sets for different things, such as civil procedure, but for intellectual property, it's governed federally. And we have the Canadian Intellectual Property Office as your go-to for resources, but also the office that collects and records all the registrations when it comes to IP in this country. And then if you can see here, there's a picture of Travis Scott in Fortnite. This is old now because I know Eminem's been there, and now Fortnite's got Lego, and you can use a skin for just about any character. But that just goes to show like how complex IP can be in video games, and how it's so easy to cross over into other forms of media, such as music. So these are just some of my, well, this is sort of like the definition of intellectual property in terms of explaining what it is at a legal level. But what I find in this slide that's quite more interesting is this quote by Philippe Poisson, also known as Phil Fish. And I'm not sure if you guys are familiar with him, but he was the developer who created Fez, and is in one of my favorite movies, Indie Game, the movie. And that's a great movie to see. What can go wrong if you don't work with a lawyer, and some of the anxieties involved. But he has this quote in that movie where it says it here, games are the ultimate form, the ultimate medium. It's the sum total of every expressive medium of all times made interactive. So think about all the different forms of media out there. It's all combined and you can interact with it. It's the sky's the limit when it comes to video games and its potential. One of the things I won't touch on, because it's a whole different door to complex questions and issues, is artificial intelligence, and how over the past couple of years that's become synonymous with IP and copyright infringement and other forms of intellectual property infringement. But it is something to keep tabs on. It's evolving, and it's not a space that's quite defined just yet, because it is quite complicated. I have my own sort of legal and philosophical thoughts on that. But if you're ever interested in a conversation on that, hit me up. Maybe we can talk. But we'll leave that for today. So we'll begin with copyrights in terms of understanding the different categories. As an example, copyrights are the characters. They can be copyrightable. The code, the art that goes into that, whether it's the character models or backgrounds or anything like that, the music, the sound files, animation movements, the user design, the user interface design, the writing that goes with that, and as I mentioned, the complete game itself. So copyrights in Canada, they're governed by the Copyright Act of Canada. And compared to some of the other categories of intellectual property, copyrights are something that are automatically given once the piece of art or the IP asset comes into creation, into reality. But then again, it doesn't mean that you have it's going to be an automatic guarantee that you'll be able to enforce that, right? And so that's why we do encourage that you still register your copyrights. Um, it's a bit sophisticated, but you can break it down. And I'll have some advice here later on about what kind of strategies you can take, you can sort of take advantage of when it comes to knowing when should you register certain copyrights and when should you just kind of leave some let alone. But copyrights are automatic, and it's one of the rights that if they're protected in Canada, they'll also be protected and recognized in 176 other countries. This is because of the Berne Convention. So if you have a copyright in Canada, you can also enforce that within the United States, China, Japan, the European Union, and many other countries. Moral rights. So this is a subset of copyright. Copyrights are something that you can transfer, you can sell, you can give up. But moral rights are something that are built into copyright that are not transferable. So this goes to the essence of the author or the artist's relationship with the IP itself. So for example, let's say you've created, and we'll think just high level here, a game. And let's say you own every single IP asset in that game. You can transfer the copyright and all the other IP rights of that to somebody else, but you can't transfer the moral right. And the moral right is something to say that I'm the author, I created this. Nobody can deny that at the end of the day, this IP came from me, that it was conceptualized by myself. This is more important when you're working with contractors or you're working with employees. With employees, for example, that IP transfer over, the employer owns it. But the employer cannot own the moral right to that. So without getting too much into detail with moral rights, it's something that always exists. It can't be transferred, but it can be waived by the owner of that moral right. And a waiver is just to say that I'm not going to be acting on my moral rights in this exchange with you. It sounds a little, okay, it's not that big of a deal because it's a subset of copyright. But where it can come into play is, let's say that you're working with a contractor and the contractors assign their intellectual property rights to, let's say, a music piece that they're working on, and now you're using that in your game. If you end up, if that contractor doesn't waive their moral right, and you end up using that game on some sort of a platform where there's maybe a political or moral dilemma that the contractor doesn't believe in, they could invoke this right and say, hey, I created this piece of art, even though I've given you the rights, I don't want you to associate my piece of art with X, Y, and Z. Sometimes it can be a big deal, especially if there's been a lot of marketing and a lot of effort on your part to get a game associated with maybe some sort of a moral cause or something like that. So it's always good to keep this one in mind because it easily slips under the radar. Then we have trademarks, another very commonly understood form of IP. Unlike copyrights, where they sort of come into sort of protection automatically, trademarks do not. They require time to be protected or a formal registration. So what is a trademark? It's a combination of letters, words, sounds, or designs that distinguish a company's products or services from a competitor. This could be something like the actual name, like Nintendo, right? Which is very distinguishable. When we think of the word Nintendo, only one thing comes to mind. Or it could be a catchphrase like do a barrel roll, which we also know what game comes to mind. And although I don't think that is formally trademarked, we can consider that that does have some of the rights that a trademark might have. So trademarks don't they get registered in each jurisdiction, and they would have to do so separately. So there's a couple of ways that trademarks can be sort of protected. One is an informal unregistered trademark, which basically means that if you use this, if you create notoriety, you build a brand, and people in general, your market starts to understand and associate that trademark with you, you can call that a trademark, and you can start to enforce that. But there's also the registration process where you would go to an entity like SIPO, or in the United States, the US Patent Trade Office, where you would register that with them. And that would then be registered in the United States. That's a formal process. It takes some time, and it can be quite complicated. It's something I don't recommend doing on your own, but working with a trademark agent when you feel that that's the right time to implement a trademark registration. You can maybe not something that is really effective, but you'll notice in this image that there's a difference between the Nintendo trademark and the EA Sports one, in the sense that one has the R encircled and the other one has a TM. The TM refers to that unregistered trademark, so an informal trademark, whereas the R is a rights reserved trademark. Now, that's not to say, and I don't want to cause any confusion, that the EA Sports logo is not trademarked or not a registered trademark. It is, but for some reason, they decided to keep the TM there to emphasize that as their trademark registration. But if you are in the process where you want to start enforcing or building sort of a precedent of this is your trademark and you want to protect those rights, you can start implementing the TM beside the name that you want to protect. It doesn't give you any guarantees, but once you can start showing that, hey, at this time I started using that, you're building a case to show that this is your trademark. That being said, it could be challenged, and you also have to make sure that there aren't any other trademark registrations that claim that trademark before you decide to do so. So I'd recommend getting used to knowing about the SIPO website. It's a great resource. There's some guides on there. It's not only the place where you can go to register trademarks, but you can also make use of their trademark database, where you can look up existing trademarks. An example of that is in this slide here for Assassin's Creed. This is what a trademark registration looks like. And as you can see, the status is that it's registered. It's a trademark. It talks about the type of trademark as well. It's a word. And you can also see when it was filed, when the registration happened, and when the expiry date is. So you'll notice in this one that the expiry date is, I think that's August 6th, 2023, or it might be June the 8th, 2023. You might think, okay, well, now that it's expired, it's up for grabs. No, that's not the case, because almost everyone knows that Assassin's Creed is a famous trademark owned by Ubisoft. It'd be very difficult to bring a claim to say otherwise. And if you look at the updated version, you can see that the registration was renewed, and now they've got that protected to 2033. So when you do go look for trademark registrations and you see certain dates are coming to registration renewal, just double check because they can be updated quite often, and something that you think that isn't registered or protected might be. So definitely give this website a look and make sure that you're aware of any of the updates there. Trade secrets. So whereas the copyrights in Canada are protected by the Copyright Act of Canada, and trademarks are protected in Canada by the Trademark Act of Canada, trade secrets don't have a formal statute, meaning there isn't a particular set of laws that are in code that you can go to and refer to when it comes to protecting or enforcing your rights with trade secrets. Instead, trade secrets are covered by what's called common law. And common law is basically a case or a set of precedents or cases over time that confirm this is what the laws are. And they're typically composed of successful legal cases and judgments by judges. So trade secrets have evolved over time to an extent, but the essence of it is still very similar. And so a trade secret is a formula, pattern, physical device, idea, confidential information, something along with that, that basically highlights an advantage that you have as an artist with your IP that maybe your competitor doesn't have. So what comes to mind is Coca-Cola and their famous protection of their recipe. That is probably one of the most well-known and well-protected recipes in existence. It's not protected by anything else other than trade secrets. And so how do you protect trade secrets since there's no actual formal statute? Well, you start using NDAs to make sure that anybody you're discussing this confidential information with, you have something there to say that nobody will divulge this, will use it for their own purpose, or leak this information. You can take additional steps as well by making sure that these types of NDA or confidentiality clauses are embedded in your contractor agreements, your employment agreements, and you implement this in your best practices for your studio or while you're working on the game. Then we have patents. Patents are not as important, I'd say, for developers because patents are typically for hardware or really unique, innovative gameplay mechanics. If let's, for example, the Nemesis engine that was used in Shadow of War and Shadow of Mordor, and even in that case, it took them a long time to get that patent. And it's a very expensive process. So it's something I would say that for indie developers, it's not really something that should be top of mind unless you are working on some sort of a hardware piece that accommodates your game and is instrumental to it. Then yes, definitely look into patents. And patents are very expensive to formalize, and they definitely require the help of a patent agent. And patent agents are a different type of lawyer. Yes, they are lawyers, but they typically have a background in computer science or in the sciences because they really do break down the differences and the sort of the hardwiring of hardware and the sophistications of that so that they can make sure they understand what the differences are between the product that you're trying to patent and a competitor. So here's an example of some common IP assets and how they fit into these different types of categories. I do have an ebook that has this sort of broken down. So if you're interested, please feel free to reach out. And we can figure out a way to get that in your hands so that you can have this on hand. It's a way for you to kind of look over your own IP assets and you can do an inventory and understand where do they go. So we have copyrights as examples of what we mentioned already, music, code, story. But it can also be like the box design if you have a physical version of your game. Can also be the website and any of the graphics that are associated with the promotion of your game. Trademarks, examples are company name, game title. As I mentioned, identifiable catchphrases such as dual barrel roll or Hadouken or EA, it's in the game. Trade secrets, these are a little bit different. These include your pricing information. It can also be who your contacts are, which publishers you've worked with, which contractors you have that work with you, can even be your employees to an extent. This is information, again, that gives you an advantage and you don't want your competitors to get a hold of.
Not yet? Okay. All right.
And I'll just pause for a second. I think we're good.
We'll hunt them down and mute them. Don't worry.
No worries. I mean, then we have patents. And again, as I mentioned, this is inventive gameplay, but can also be parts of your hardware as well. So if you have, let's say you're working on a VR game and there's an element or an add-on feature, physical device, that might go with, say, Quest or the Valve Index or something that is very unique and you want to patent. Another example might be, this is quite a popular space, but there's a demand for controllers that are built for mobile devices. So they fit around your phone to kind of have a nice ergonomic sort of gameplay. That's something that can also be patentable. So we're going to get into some of the topics around strategic IP protection. And IP should be protected. It's probably the most important part of your video game. Why? Because, as I mentioned, it's not just the game, but it can be broken down into a variety of different IP assets. And as you've now sort of discovered when it comes to trademarks and trade secrets, it's not even just the character models or the music, but it might be the title, it might be the catchphrases. You know, you might be creating characters that have their own background stories that you might want to create ancillary products out of, or derivatives out of, or sequels, whether that's a TV show, whether that's merchandise, physical merchandise, such as toys or plush models or something like that. It all starts at the top with your IP. And the best way to get started with this is to start building a portfolio. So a portfolio is, it can be very sophisticated. It can be anything from, hey, I've tracked all of my IP that goes with this first project that I'm working on. I know who created the character models. I know the title and who created that. And you're able to track that and build a sort of profile and portfolio out of that. And you can compare that to, say, maybe what Ubisoft has. And I'm sure they've got banks and banks and banks of computers of IP assets that they've tracked in their portfolio. Now, your portfolio isn't something that you just want to be using for your game. This is something that you're going to be using to grow your studio as well from a financial point of view, right? This is the most valuable asset that you have. And so it's important to make sure that you have a portfolio that is clear, is organized, and you can track. Because when you're having conversations, when you're pitching for funding, or you're having conversations with publishers, you want to make sure that you can refer to your portfolio to make sure that, yes, you can track your IP, you own it, you know what your rights are, you know what pieces of your game go where, and that gives you more value when it comes to having conversations with publishers or other third parties. So some of the strategies that solo and small indies can start implementing when building their IP portfolio is, well, copyrights again. They automatically exist once you've created that piece of art. But you could take it a step further by going to the SEPA website, and yeah, I think the SEPA website is a good place to start. You can go there and you can register your copyright with the government. So they've got it on hand. The difference between this and not registering is that, yes, you can have a solid IP portfolio, and you can say that on January 24th, 2024, I created this character model, and today is May 5th, 2027, and I've got a clear line showing that I've owned this IP or this copyright since that time. You can do that. It's a strong piece of evidence if you're ever to be in a situation you have to enforce your claim. But if you just go on to the SEPA website and you make this registration with the government, they've already got that covered for you, and it'll say it was registered on this date, and they have that on file. So if any issues happen and you need to enforce that through a cease and desist, a DMC takedown order, or you end up in court, you can rely on that, and it'll give you additional protection as compared to, say, you keeping track of things. Although that is an amazing place to start, and if you can argue a strong case, you can rely on that evidence as well. So I would recommend registering a couple pieces of copyrightable IP. If you have strong character models that are starting to blow up and maybe your community are becoming quite interested in, might be a good idea to register that before you have some fan fiction or something that you just don't agree with and ends up going a whole different rabbit hole. And you want to make sure that at the end of the day, you can still claim that you own this piece of IP and you were the one who came up with that. Trademarks, these can be fairly expensive when it comes to registering them. So it's also good to keep in mind that we want to create some sort of strategy around this as well. A good place to start might be if you have a game or a title that's become quite popular and it's unique and it's something you want to protect, that might be something that you submit an application for. It could also be the name of your studio, right? Nintendo's done that as a big publisher. And as you grow, you'll probably start collecting and adding more trademarks to your portfolio as well. NDAs, best way to protect this, and it's the easiest way, at least legally speaking, without having to do any registrations, is just making sure that you're not divulging or over divulging on information or confidential information about your IP or your game or your studio that you don't want others to get a hold of. It's very easy for this to slip in a conversation, especially when you're really passionate about the subject matter. But that kind of starts with you in terms of how you're going to protect that. It can be done by how you conduct yourself, but you can also go and formalize this by drafting up an NDA and having the other party sign that NDA so that you can speak freely on the matter and hopefully make sure that they don't end up infringing on that. IP clauses to your agreements, whether that's contractor agreements, any type of agreement that you're going to be working with another party and it's going to involve the IP, make sure you have some sort of a clause in there that recognizes and distinguishes the use of that IP. So as an example, when you're working with contractors, and what I mean by that is, say, freelancers, somebody who you're not employing as employee, and there's a big distinction between an employee and a contractor, which is a whole other topic. But distinguishing that and making sure that the IP that contractor creates, that you know who ends up owning that IP, whether that's yourself or whether that's them and they've given you a license to do so or the right to do so. It's important to have that included in contracts so you can at least start to track and you understand who owns that. And yeah, to sum it up, track your IP. See how you can break it down, try to get a good understanding of it and track it. It's something that can be a lot of work if you haven't done it, but if you're just starting out, create that practice of identifying your IP and start tracking it. So I mentioned about NDAs. Here's a little bit more information on that. There's different types of NDAs. There's something that you can kind of give out unilaterally. If you're having conversations with publishers, they might not be interested in signing them, but I would try to get them to sign it regardless, because at the end of the day, you don't want to have another game coming out in 7 years' time, which is being released by the publisher you had a conversation with, and that publisher had turned you down at that time. It can't happen if you don't have an NDA or any proof to say that this was yours. It's difficult to enforce your rights to that IP. Wanted to also briefly touch on two unique situations that are common to indie developers when it comes to protecting their IP. One is, going to game jams. What do you do in that situation where you're working with people for the first time? And, after coming out, you might end up having a project that you want to develop into an actual game and put it to market. Well, even in game jams, being such an informal place, it's good to have that understanding right from the get-go. And if you need to, grab a piece of paper and a pen and just write something out, just to say, hey, this is our intention. If something happens out of this, we want to make sure that, these are the people that are involved and we had an interest in that. That goes a long way, because if you remember in that film, Indie Game, the movie, Phil Fish, he had some doubts and he was very anxious. I think it was at one of the GDC events where he wasn't sure if he even had the rights to that game that he was going to be promoting. So if you can get this kind of stuff cleared up at the beginning and, maybe as early as a game jam, that'll go a long way in relieving a lot of your fears. The other item is, well, what happens if you're employed full-time, but you're working on a game on the side? And I've had many clients where they're working with AAA developers, but they've got their own studio. And when you look at their employment contracts, these studios will say that they'll own all that IP that you're working on. So you want to make sure that if this is the case, that one, you get permission from your employer to create your own side projects. And this shouldn't be just verbal permission. Get this in writing. Get it amended into your contract if possible, because the last thing you want to have is a successful game that ends up selling millions of copies, but that AAA developer that you're working on says, "Oh yeah, that's mine," and we're going to go down that route and just uses that IP to create exclusives, DLCs, yeah, you name it. So these are some things to just keep in mind at the beginning. And I have a blog on my website as well that kind of touches on this topic a little bit more if you want more information. So IP utilization and licensing for indies. There's a lot of different ways that your IP can be sort of interacted with, or you can end up coming across IP other than just you creating that IP yourself. Right? Especially as indie developers, you might be relying on third parties for assets that are already existing, or even engines, such as with Unity or Unreal. And you'll end up, when you start using their services, you'll probably end up signing some sort of a terms and conditions or agreement that outlines who owns the rights to the IP assets and what's created out of that. Typically, those are safe. And they do allow you to create your own games and market them and monetize them. Sometimes they take a cut. I mean, we know Unity was in hot water with what kind of cut they wanted to take towards the end of last year. But just understand that there's a difference sometimes between between owning the IP outright and having a license. License, there's usually strings attached. So that might end up happening if you're relying on third-party engines or assets. IP licensing and assignment. This goes back to tracing. If you're working with third parties or you have employees or contractors, you want to know who owns the IP. And this can go for yourself as well. If you have a studio that's incorporated, right? You might be the artist who's creating all the IP, but you might not end up having some sort of an assignment agreement confirming that your studio has the right to use that IP. It's something that's very simple, but sometimes it's overlooked just because it is something that's almost taken for granted. So just keep in mind that if your studio is the one that you want to own the game for whatever reason, that you can make sure that there's some sort of a tracing between your rights being transferred to the studio, so that your studio can produce these games and enter into agreements such as publishing agreements or platform agreements to get your game distributed on platforms such as Steam, or maybe even with the Sony PlayStation Network. Publishing agreement. This is another topic on its own, but I wanted to just quickly touch on how IP is important when it comes to these types of agreements. Now, publishers, the way that they might interact with indie developers or studios will vary depending on what needs you have of publishers. They can be very hands-off. They might just help you out with marketing, but they can also be very hands-on, and they might even give you some staff to actually help in the development of the game itself. And so understanding the IP and how that's distinguished in this relationship with the publisher is very important. And that's what makes publisher agreements sometimes, I would say, one of the most complicated agreements there are in this industry, because they can just be so simple with some of them, but they can be very complicated with others. And I've had clients in the past where they've signed multiple publishing agreements and everything's gone smoothly, until the developer started to grow and have a reputation for producing highly successful games, and the publisher ended up slipping some clauses in the next iteration of the publishing agreement, which ended up giving ownership of that IP to the publisher. And the developer didn't know because they just thought this is just like all the other agreements. So definitely be careful when it comes to dealing with publishers. Not to say they're bad, but they come in all different shapes and sizes, as do developers. And so just be vigilant, because again, your IP is the most important thing that you as a developer have. So kind of summarizing then with IP, some of the basics to keep in mind, that's a good sort of starting place, is make sure you can track your IP, you can categorize it, and you understand it. Now, we've talked a lot about IP when it comes to enforcing your rights and protecting your rights, but your IP is also the thing that's going to generate revenue for your studio. Whether that's your intention or not, it's going to. It's going to be the thing that you can use in the future. You can make sequels of, you can make derivatives of. You might end up having a movie based off of your IP as well. So making sure you understand these aspects of IP is crucial. And it starts with making sure you understand who owns that IP, whether you can use that IP in your game or in something else. Do you have the rights to do so? Understanding what your rights are related to that piece of IP, and also understanding what rights do others have in your IP. Sometimes when you work with, let's say, musicians, especially musicians that might be based in Europe, they have additional protections when it comes to the rights that they have. And some of them may not want to give you full ownership of the music that they've created. So it's important to know where the lines are drawn and where they end when they come to your ownership, and whether something is considered a license. And now I've used this term license quite often, and forgive me for not sort of explaining it, but it's another aspect we can go into great detail about. But a license is not ownership, but it can almost be like ownership given how that is, let's say, drafted in an agreement or in a clause. But a license is basically saying you have the right to use something based off these terms and conditions that the owner has given you. So as we come to the end of this presentation, I wanted to mention a little bit about working and collaborating with lawyers. So myself, and perhaps I can speak for other lawyers, but typically our work involves providing you with solutions, providing you with guidance, and providing you with protection. And it's also important to understand, because I would say there's not many lawyers out there that will say, well, I'm a video game lawyer, or I work a lot with video game developers and publishers, so therefore I understand this industry. But that doesn't mean that you don't need any other type of lawyer, or that other types of lawyers might not be able to help. So it's good to have a sort of an idea of what kind of lawyers you can work with, and what areas of law that they might practice can be very helpful for you as a video game developer or studio. So typically in the areas of what I call video game law, we have aspects of corporate and commercial law or business law. This is typically related to the setting up of businesses, structuring, making money, and basically governing the structure and operation of, say, a studio. A corporate lawyer will be somebody who might help you set up the studio, and might allow you to, and might also help you draft up contracts as you engage with other parties. An intellectual property lawyer, it's a bit self-explanatory, but this is typically a lawyer that understands those categories that apply to intellectual property law. They might have their own sort of areas of focus, such as trademark law and be a trademark agent, or patent law and be a patent agent, but they also should sort of have an overall understanding of intellectual property in general. It's, as I mentioned, in video games, it's quite sophisticated. So I would recommend having a lawyer that understands how intellectual property exists in video games and appreciates that, because as I mentioned throughout, intellectual property is the most important aspect when it comes to law in video games. A contract lawyer, because ideally you want to have a contract for everything, and not to sound that, this is very burdensome, but if you think about all the different relationships that you might have with anyone involved with your game, it's a contract exists whether you have it in paper or not, because you have a set of expectations between the two parties of how they're going to interact with you or your IP or your studio. The reason why we have contracts is when things go wrong, you can actually go to the piece of paper and say, this is what we agreed on, right? So having something in paper is ideal. There are plenty of lawyers that can assist in creating the right types of contracts. But again, if you can find a lawyer that can help you understand the different type of dynamics that are involved with video game development, that'll go a long way. And that might be a corporate lawyer that has some experience in intellectual property. It might be a corporate lawyer that has experience with video games. It's all about finding that right sort of fit. And without going into too much detail, a lawyer that can help with employment. Employment law itself is a whole different field, but you might find intellectual property lawyers or corporate lawyers that dabble in that area. I do recommend, if issues do come about related to employment and you need competent level advice, an employment lawyer is better than going to a corporate lawyer for these types of matters. And so myself, I am sort of a corporate lawyer and an intellectual property lawyer, and I understand the video game industry. So I take these areas of law and I take my understanding of the industry and I apply my skills to that with that understanding. And there are a couple of us in Canada that sort of operate solo or in small firms, and there are many of us that operate in big law firms as well. So depending on where you are, myself, I'm in Ontario and I'm licensed to practice in Ontario. I can assist clients around Canada, but I can't show up in court. And so I'm limited by that. But there are lawyers that might have license to help and practice in Alberta as well. And they'd probably be a better fit when it comes to enforcing some of your legal rights. So yeah, in summary, lawyers are here to help you navigate the laws that are involved. And the laws are always there when it comes to your IP or running your studio. And oftentimes, many people think about lawyers when things go wrong, when things go south. I need somebody to bail me out and help me because I'm in a dilemma. And while that is what lawyers are helpful with, we're also helpful with being proactive, helping you kind of come up with strategy at the beginning so you can avoid these issues in the future or at least limit them. You can think of lawyers as sort of your guide, your strategist who's holding the compass while you sail your ship and tells you, hey, this is what we need to do because we have this obstacle coming up ahead. So you're best planned. You have a plan in place to deal with that. So that's just sort of a different sort of spin on how you can think about lawyers and how you can utilize lawyers to help you build your studio and avoid issues and build a successful business. So that kind of summarize, or that ends the presentation for today. I know, and I apologize if some of this stuff was a bit too high level. Intellectual property, as I mentioned, can be very, very deep, and we could have had 2-hour, 3-hour long sessions on each subject, and you'll probably all fall asleep because it can be quite boring, but fortunately it's not boring for lawyers, and that's why we can talk about it. But yes, I hope you enjoyed the presentation. I hope you learned something. Even some of these tidbits you can start implementing today. Maybe even just starting out and assessing the IP that you have. Start organizing it and making sure you're covered. As I mentioned, feel free to reach out, whether that's myself or representatives here at Digital Alberta, to get a copy of my ebook, because I kind of break down some of the other things that we didn't touch, but it also includes some of those charts that you might find really helpful to get you started on breaking down and understanding your IP.
Awesome. Thank you
But
so
yeah,
much,
thank you.
Mara. That was really amazing. I think that was a really great high level introduction to so many different pieces that are so relevant to our studios. So I will go to a few of the questions in the chat now. So Diana asked, how soon should I start the trademark process registration? Can I get a trademark on a name that another company is already using?
Okay, so those are good questions and two questions. We'll start with the first one, or we'll start with the second one because it's probably easier to address. When it comes to trademarks, yeah, make sure you've done your research and see if another company has it. If that other company has it, it gets a bit complicated. If this is something that you are claiming a trademark to, and another company's already gone and done it, I think we'd have to sort of dissect that to see who had a first claim on it, to see if that is something that you can enforce. Now, if it's a situation where it's a trademark or a name that you want to trademark, but unfortunately somebody else has taken it, you might be able to trademark it. It really just depends what the usage of it is. The laws are a little bit flexible. Sometimes, like as an example, Apple, the computer company or the tech company or the data company or whatever they have trademarked Apple. But an apple is also something that maybe a farmer produces, and maybe there's a farm that's trademarked Apple in some sort of a way. So understanding how that trademark is being used can also make a difference in whether you're able to trademark or register that trademark. So it's something you'd have to break down case by case. Off the top of my head, I think I have an FAQ section dedicated to this question on my website. Yeah, might want to check that to get a little bit more information. Now on the first question, if you don't mind, Paisley, just reading that out again.
How soon should I start the trademark process registration?
Okay. Ideally, as soon as possible. But it's better to have some sort of a strategy and understand what you're doing with that trademark or that copyright registration. So as I mentioned, copyrights, you kind of have that copyright automatically once you create that piece of art. And so from that moment, it's a good place to timestamp and say, hey, on this day, I drew this picture or I created this script. And then when you go to register, you have to fill out a form and you can say what that date was when you created that piece. And you might just be asked to kind of prove that you did on that date, but you might be able to backdate it to that actual date, even though the registration is, let's say you created it last year, but your registration is today. You might be able to get that protection to go retrospectively because that was actually when that copyright came about.
Awesome. So the next question from Isaiah Hurt is, how can you protect your IP when pitching to publishers at events like GDC or Gamescom? Awesome.
Very good question. And it's difficult because as much as I could advise you as a lawyer, and again, this isn't advice, but let's say I was, to say, hey, get an NDA signed, make sure you don't say anything until you're assured that they're not going to take any of this confidential information from you. It's difficult in reality, right? Because you might be in a position where that publisher has a lot of leverage over you because, it might be to your favor to work with them because they might, launch your career. And you might also be kind of lost in that moment of having this conversation and just say, hey, I just want to put myself out there and see if this publisher, bites the fishing line. Now, it's important to try to be as composed as possible and be aware of what information you want to talk about and what not to. So you can do some preparatory work before you go to an event like GDC. By doing your research to see what kind of publishers are going to be there and who do you want to scope out to have a conversation with, and sort of have your conversations, or at least the key points that you want to discuss in your conversation, outline in advance. So let's say you don't go down the route of presenting them with an NDA. If you have a list of these are the things you want to talk about and you've confidential information in this that you're afraid of sort of divulging, then try to stick with that list. If, and I'm not sure about the success, especially for an event like GDC, but you can also potentially reach out in advance, and let's say a couple weeks in advance, and say, I'm going to be at this event. Here's my website. This is what I do. I want to have a conversation with you. Now, I have an NDA because I want to make sure that some of this information remains confidential. If you present this early on, you have a higher chance of that NDA successfully being signed. Now, if you go into that meeting at GDC and you say, I'm not going to talk to you until you sign this NDA, good luck. You're probably not going to end up having that conversation with the publisher.
Great, that's awesome advice ahead of GDC. Our next question is from Tyler. Is there any easy way to look online or with a lawyer to check for trademarks?
Sure. If you give me 1 minute, I'll find you the website that you can go to and take a look. So this is for the trademark database that you can find on the CIPO website. And let me just quickly pull it up. So I'm just going to put it in the chat here. It's the Canadian Trademarks Database. So one of the things I want to just clarify is just because you have a trademark registered in Canada doesn't mean your trademark is enforceable in the United States. You might find that another company in the United States has already trademarked your trademark in the US. And so you might end up having a trademark in Canada, but you can't get it in the US. These situations happen. So as Canadians, I would say it's good to keep in mind what the Americans are doing first, because that's naturally your largest and easiest market to sell your game to or get it out to. So when it comes to, let's say, copyrights, that's okay because that's easily recognized at the international level. Trademarks aren't as much. And sometimes it might not make sense to if you can only choose between doing one registration, it might be better to make that registration in the United States over Canada. And you might end up having to work with an American lawyer or trademark agent to help you with that. There are, of course, many Canadian lawyers that can help you with that too. So check out the site. You can type in some of the trademarks and see what shows up, especially if it's something that you're looking to. But if you want to truly understand what does it mean, how does it apply to you, what rights do you have, then I recommend working with a lawyer closely to understand what your rights are there.
Thank you. That's great. Are software-enabled patents common in the video game industry? I'm familiar that software is a difficult area in patent. That's an awesome question.
Yeah, it is a good question. And my apologies as I'm not a patent agent. And that's one of the areas that's outside of my practice. But from what I can speak on is that patents and softwares are quite complicated because as opposed to say hardware, it's a little more difficult to break it down and to distinguish how it's going to end up being used. So to touch on patents a little bit, patents aren't really a right. Well, intellectual property is kind of like this in general, but patents force others from creating something that you've already done. So it's kind of like a stop sort of protection mechanism. It doesn't give you a right to something. It just prevents others from creating something similar. And so when it comes to software, it's a little more difficult to say, hey, what this software might end up being used for, because it might have one particular purpose initially, but it could be tweaked a little bit and it might end up having another purpose. So it is very difficult, and I would recommend speaking to a patent lawyer to get more information on that.
Awesome, thank you. And I think this is the last question in the chat. Another one from Diana. Another question I want to make sure it is very clear is that if I have a company and an employee created examples, some 3D models, I understand they have moral right, that they could exert them if needed. the intellectual property of the artwork, for example, belongs to the company, though. Is that correct?
Yeah. So by sort of definition, employees are essentially the work that employees produce is automatically owned by the employer. That's just the nature of the relationship. And in return, employees have, guaranteed work or employment. They get benefits. They get all these other rights essentially. And they're also protected by the Employment Standards Act of Ontario, for example. Ontario and Alberta's got their own version of that too. So with these protections, yeah, the IP that they end up making gets automatically transferred to the employer. Now, this is sort of an automatic right, but it's best practice to have an employment agreement that actually stipulates this too. Then there's no doubts about that. Now, even when it comes to moral rights, that you can have language in your employment agreement that says, I, as the employee, waive my moral rights. That's very common, and you'll find that in many agreements. That way, you can kind of navigate around the moral rights protection. And so you can probably, if this is your employee, you can probably deal with both of those issues by having an employment agreement that clearly deals with those 2 points and addresses them.
That's awesome. Yeah, I think that really speaks to the fact that we all need to make sure that we have good employment agreements in place. So I think that's a main takeaway from me from this call. We do have 2 more questions, so these can probably be the last 2. Is there a US counterpart or site that you can look to investigate or register their trademark copyright in the US market?
Yes, there is, and I'll find you the link as well.
And then the next question is, what are the ways to ensure I'm avoiding breaking open source software licenses, such as GPL, which may require I open source some of my code?
So to the first question, I've sent the link to the US Patent and Trademark Office, so you can do some searches there. Now this question, that's a good one, and I'll say I don't quite know. It would depend on which open source license you're using. And as a rule of thumb, when it comes to open source, it's be wary, because yes, it sounds like, oh, it's open source, I can do what I want with it. But sometimes they too have their limitations in terms of what ends up happening with the product that's created from that open source, right? It might also mean that, let's say you've created an IP or some sort of a tool or something that expands on that. There might be something in that open source that says, well, if you create something, whatever creation comes out of that is also going to be open source. And so others might be able to manipulate that. Now, in terms of your particular question, it's difficult for me to say. And we'd have to look at what that particular open source license is before I can comment.
I think that's all the questions in the comments. Got a lot of great feedback, which is awesome. I hope this was beneficial for everybody. We really enjoyed having you, Amar. And hopefully everybody will go download your ebook so that they can get more information on some of these topics. And of course, reaching out to Amar if you'd like to work with him. Yeah, so thank you so much. And this is great, especially in advance of GDC and the game jams coming up this weekend. So don't forget to protect your IP. And we will hopefully see you at our next webinar with Jason De La Roca in a few weeks.
Again, thank you for having me. It's my pleasure. And also, Pace, I have a couple of tip sheets as well. One is actually designed for just sort of some things to keep in mind as you're having conversations with publishers. It was actually made for to hand out at events like MIGS and XP Gaming Summit and GDC. So I have that. I'll send it an email to Paisley or Ruby or Alicia, so you can distribute that as well.
Amazing. Thank you so much. I hope everybody has a wonderful rest of their day, and we'll see you soon.
Thanks,
care,
everyone.
everyone.
Great to see you all.